Good evening. Good evening, everyone. I am Siaman Rajput, moderator of today's webinar. We are delighted to welcome you all in the webinar being organized by the Committee on Commercial Law, Economic Advisory, and NPO Cooperative of ICAI, which is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value by combining analytical fortnight with commercial acumen. The core area of the committee is to serve the multifunctional task of analysis, spreading knowledge, providing inputs to regulation and policy formulation to develop and publish technical guidance, background materials, etc. Also, this committee works on creating awareness for professional opportunities for chartered accountants in commercial law, economic advisory, and NPO cooperatives. In today's webinar, our eminent speaker, Dr. Kishore Deresar, is going to talk about professional opportunities for CAs in alternative dispute resolution, or we can say ADR. Hoping this will be useful for all our members. Now, let me introduce our speaker for the session, Dr. Kishore Deresar. Sir is an expert in mediation and conflict resolution, recognized as a Fellow of Chartered Institute of Arbitrators in London. He holds doctorate in international studies, philosophy, and law, and have completed various specialized courses in intellectual properties and climate law from WIPO and University of Cambridge. He has presented research at renowned institutes and universities like Oxford, Geneva, and Loyola Chicago, and has received fellowships for his work worldwide. He also teaches at various institutes and volunteers as reviewer for Canadian academic journals. He has published widely on topics such as law, politics, and the environment, showcasing his broad knowledge and global contributions. We welcome you, sir.
Thank you, sir. Can we start now?
Yes, we can start.
Thank you so much, sir. And you see, it's an opportunity for us to again discuss this very critical issue for everybody. And as you see, me, the world keeps evolving. So the different walks of life and disciplines and the professions, they also need evolution. And that's happening in various walks of life and professions. So dispute resolution is one such domain where you see this hybridization or the cross fertilization of knowledge and practice from different disciplines is desperately needed. And from that perspective, if you look at the role of not only chartered accountants, but also of various professions, of course, you see, we are going to focus more on CAs, but generally, you see, the traditional or conventional understanding is that dispute resolution means primarily, you see, the lawyers, judges, and the courts. And it has, you see, me a very valid and solid, authentic, genuine reason for having, you see, this kind of the understanding and the approach. But the experience of the societies world over has shown that you also need to have the knowledge and experience that can benefit the humanity as such. And that's why the field of alternative dispute resolution has emerged in general. It's, again, you see, it's not something brand new. It was there in the ancient societies. But from the modern perspective, so it is again, it is projected as something very new. But those who study history and keep in touch with the grassroots level society, the so-called backward societies or the tribal societies, so those people will be knowing that such means of dispute resolutions already used to exist. But in the modern context, these are something new, and that's why they are called alternative. Alternative to what? That the dominant or the prevalent mode of court-based litigation, which is supposed to be very long drawn and then expensive, time consuming, and in terms of output or the outcome, that it ensures that only one party wins, and therefore the losing party has some kind of bitterness. So the broader goal of dispute resolution, that is to ensure peace and harmony in society, and ensure that people are having amicable relations. So somehow that is not ensured. So this is the broad framework which has given rise to this ADR mechanism as such. And again, the Western world has taken the initiative, and since we are having this approach after colonization and so many the foreign rules, that we tend to follow the Western models. So here also we are doing that kind of thing. But if you look at history, so you will see that traces of these mechanisms used to exist in India also. After having ITC, seen these things, now let us come to the various professions and the chartered accountants. So, as the dispute resolution, the experience world over showed that the drawbacks of the court-based litigation, and therefore the involvement of the institutions other than the courts. So, whether it is the mediation, arbitration, conciliation, negotiation. So, initially it was supposed to be something very informal, but that was the earliest stage, and that is quite natural. As the processes, the alternative processes of dispute resolution began to be adopted world over, and the parties and stakeholders are from multiple places, national and international jurisdictions. So you obviously need some kind of framework, and that leads to gradual formalization. So it is not 100% informal as such. Although the books on the ADR, they always use these words that these are informal means and very time saving, cost saving. So that may not be true in absolute sense of the term. That is to be noted. Yet these are the means which are different from the court. And here you see it comes the roles of the different professions. It seems the lawyers and the courts and the judges, they are required to have very rigorous procedures which take a lot of time, and the rights of parties deserve to be protected. But if the parties are willing to forego some of the rights bypassing these strict procedures, so disputes can be resolved through these so-called alternative means. And here the nature of disputes also matters. The disputes can be obviously commercial nature, or scientific and technological matters, family matters, engineering, the navigation, aviation. You look at, you see any number of disputes. So you need involvement of psychiatrists, psychologists. If you look at, for example, you see what is happening in the wars between Israel and Hamas, or Ukraine war, or any such place where you see people are lot of having this trauma, suffering. So it is not merely see the compensation which will help them. So there the role of psychiatrists will also be there. Or just recall what happened last week for 5 6 days in Los Angeles. The highly you see this celebrity place, but when you see the fires broke out and the devastation started, the extent of devastation was such that what was this is something the iconic city of the world. So many parts of that city turned into ashes in few hours. Now, if the dispute resolution is coming there in terms of insurance companies or the valuation of property, so the lawyers and judges who are having the traditional approach or the knowledge of law through social sciences, literature, so that may not be of great help. So environmental disputes, commercial disputes, and many other disputes which need knowledge and expertise of different professions. So there, the role of the professions other than people coming from law is of great use. And as far as chartered accountants are concerned, so their role can be classified or divided into two types. Either as you see these chartered accountants, or the disciplines in which you see they can contribute on the basis of you see their general life experience and the negotiation skills. When we are talking about ADR, so broadly it has two methods: arbitration and mediation. Now, India has also adopted the mediation bill. India was also one of the leading parties to the Singapore Convention in terms of signing it. And Arbitration Act is being amended so many times. So that shows the significance that is being attached to alternative dispute resolution mechanisms in India. And as Indian economy continues to grow and expand and diversify, so one can say that the pure role of CAs will be very great. It is if you look at the commercial disputes or the big you see, industrial houses. So these are also family disputes. So it's a kind of you see, combination because the businesses dynastic properties. So if there are you see, family disputes on the issue of property, so it's a family dispute as well as the commercial dispute. And if whether it is taxation, valuation, assessment, damages, any number of things, where the chartered accountants are the most suitable person, the expertise which they have, the others don't have, lawyers and judges do not have. Just as in scientific and technological matter, the people from science and technology are going to play a very critical role. Or if it is pharmaceutical dispute, trademark dispute, so every field, banking, insurance, so the objective of the ADR mechanism is to expand the pool of dispute resolution professionals. And there is no doubt that the knowledge, experience with the community of chartered accountants brings will play a very valuable role. Uh, so looking at you see these issues, the CAs, and again you see it's not going to be confined to only one city. As the Mediation Act is going to be implemented gradually, there will be Mediation Council of India and then Arbitration Council of India. So whatever is training is required to become a successful dispute resolution professional. So it is different from LLB and that kind of thing. So training in arbitration, training in mediation, that is also important. Those who undergo that training, so they will be certified for persons. Since now, because you see this informal, that is only in the old sense. Mediation Council of India and Arbitration Council of India, they are going to be set up very soon. And once they are there, so prescribed training is required. For mediation, as of now, it is just 40-hour training. In arbitration, there are different institutions, including the ICI, which are offering training to become the persons who are proficient in these dispute resolutions methods. Of course, is immediate practice and experience, they have their own role, but the initial training is required. So those people you see from different you see, backgrounds, whether they are in medicine, engineering, aviation, accountancy, so if they want to join this field of dispute resolution, so it is in their enlightened interest to get the certified training and become accredited mediators as well as arbitrators. And how to since you see me the CAs are already having you see the clients and the customers, and they are you see, aware of the requirements of society, so they won't have I think too many difficulties in getting clients. Either you see me if people you see want to focus only on dispute resolution, then they can start their own institutions or they can join some of you see the leading firms. More and more new platforms are required. There is also online dispute resolution for which one need not have any kind of the physical infrastructure as such. That is also one of the requirements. So CAs playing a role as dispute resolution professionals as purely as chartered accountants, that is the primary commercial disputes, and the scope for chartered accountants even in other disputes, whether it is the neighborhood disputes or the family matters, the property issues, partnership. I mean, there is no dearth of disputes in society because somehow it is human nature to disagree and have the difference of opinion. The question is how to peacefully resolve those disputes. and that too without going to court, or uh, if the disputes are settled before going there, so that is always welcome. The reason is that the number of cases which are there in the courts at various levels, not just in India but even in other countries, that number keeps rising, and the uh, judicial institutions are not getting enough time. Also, the nature of, you see, the society keeps changing as the society becomes more and more modern or westernized. So implications of that will be that people will be more and more focused on rights and less bothered about their duties. So everybody wants to protect their rights, and without, you see, bothering about the rights of others being violated. So whether it is the online, the purchase, or online any transaction, the problems are going to be there, whether it is physical or online. And the chartered accountants, as you see the more and more industrialization happens, there will be great role. There is and there will be. The only question is how to me tap this potential. So having the training and getting, you see, some kind of exposure to these specific fields through different institutions which are already there, or having collaboration with the institutions. Now the initiative that has been taken by ICI, that itself is very important. The training which they are offering in these fields, that matters a lot. So, it is, you see, the choice of every person whether they would like to restrict themselves to the specified field which they are specializing in, or they would like to go beyond, you see, their domain knowledge also, because there is ample scope and opportunity for that also. So it has, again, you see, the implications and the requirements. Those who would like to restrict themselves only to the domain knowledge, so the one which they already acquired and the expertise they have, so they just have to diversify to the dispute resolution. But those chartered accountants would like to go beyond this and use or join this dispute resolution profession in the bigger sense. So they will have opportunities beyond the uh, domain knowledge also. Uh, so it's for, you see, every person to decide. And again, it can be, see, nationally and internationally also. If you look at, you see, the foreign investment that is coming into India, so the corporations are already there and more will be coming. So that is one dimension. International also means that if you would like to go beyond India and be on the panels of the foreign institutions, so after getting the training and experience, so one can be, see, part of the international institutions also. For example, Singapore International Arbitration Forum or Hong Kong International Arbitration Center. In India, also number of such institutions are there. Either they are having, you see, the collaboration with them, or they are having their own forums. So again, it's the choice of the person. How much does he or she want to diversify and broaden the horizons? So confining oneself, it is the pure, is the discretion of the person and choice, and how to use this opportunity. So there is no doubt that whether it is the pure, is the domain knowledge, or going beyond, is the domain knowledge, avenues are there. Only question is who wants to be taking the leading role, and how much does one want to contribute, how to become competitive, how to offer the services. Because here, you see, me, one needs to remind oneself of the fact that we are service providers basically, whether lawyers or the chartered accountants or doctors, architects, all the professions need to remember, members of these professions, that we are there to provide service. So we are not, this is some kind of the kings or sovereigns or the emperors. So those who are having that kind of approach and the credibility in society, also the institutionalization of that. The traditional approach of lawyers has been, you see, that they are ad hoc practitioners. So in India, you will see that there are a lot of ad hoc arbitrators and ad hoc mediators also. But now things are changing, and the focus is more and more on institutional arbitration, institutional mediation. Once the Arbitration Council of India and Mediation Council of India they are set up, the focus is going to be more and more on institutional arbitration and institutional mediation. So as me earlier, I was saying that me one can join the existing institutions or launch one new institutions also, or me there can be collaboration between various institutions. As far as ODR is concerned, online dispute resolution, so that is also coming through institutional fora or the individual practitioners. So it's a matter of getting clients and through outreach. And how to do that? By participating in seminars and conferences on these issues, writing on these matters, so that the prospective clients know. Of course, you are having the clients for the purpose of accountancy. But if you need to go beyond that and be part of the dispute resolution profession. So the parties who are going to disputes, and if they are in search of the dispute resolution professionals, so they should know that who is where, what the level of expertise. In case people join the institutions, existing institutions, so institutions are having their websites, and on that the resume or the CVs or the biodata of various professions who are associated with them. That is pool of the professions. So that is available on the websites of the institutions, and the dispute resolution uh, professions who are there, and the parties who are in search of them. So there can be the online the contact. But those who are having the uh, ad hoc practice, so they also need to either their blogs or websites. So writing on these issues, being part of these networking events, publishing on these topics. So that is me one of the ways to get work on this issue. Apart from what the work that chartered accountants are already doing, these are you see me some brief you see points. The main you see me point the concern is that how to get work of our me everybody asks. Those who are already established, they don't have such worries. But those who are, you see, the people who are joining or now, or they want to diversify, so they may have such concerns. Even the CAs who are doing the ADR courses, so they also keep asking such questions, and it's quite natural. Whoever is doing any such professional education would like to get the work. So by getting this training and exposure, and also diversifying one's own existing domain knowledge, also joining the institutions, going beyond you see, the traditional domains, one can be accessible to the parties who are in search of the professions, and thereby one is willing to offer services. So it has to be done through lawful and ethical means. That me applies to all professions. So CAs are already aware of that. The mediation council, arbitration council, once they are there, they will have you see some mechanism for accreditation, assessment of the institutions as well as individuals and professions. Since they are not there as of now, so we don't know what exactly will be there. But the people who are qualified to practice in ADR, so they are not confined to merely to law. That needs to be noted. So every now and then, you see, these doubts are coming whether the non-lawyers can join or not. Yes, they can join. They are required. Law requires them to be there. So we need more and more to see the diverse uh, pool of people who are in the field of dispute resolution, and chartered accountants have an ample scope, and the society needs their services in the field of dispute resolution. And it is not just merely again you see the courts and the lawyers, and the procedures which the ADR mechanisms offer, they are substantially different from the court-based litigation. Here, the flexibility is there. The parties can choose the arbitrators and mediators of their own choice, depending on the expertise, the linguistic competence, availability, because the very high profile people are in demand. So if the parties are chasing them, and if they are not available, then it doesn't serve any purpose. So parties also need to have this confidence that the professionals whose services they are going to seek, they should also be available. Their expertise, their experience, their overall, you see, the approachability. These are, you see, the factors. And this apprehension which is there in the mind of so many people, that the new laws which are coming, whether it is the Commercial Courts Act or the real estate disputes. So everywhere you will see that the overall trend of the new policies of the government is that, you see, the dispute resolution should be done expeditiously, amicably. Less and less time should be spent. The interests of parties can be saved. Mediator, you see, again, you see, plays a great role. Unlike the arbitrator, who is there basically to uh, give award in favor of one party and against the other party, mediator is playing a different role. Mediator is supposed to be third party neutral, and very often the parties who are having disputes, they tend to adopt very rigid positions. And in that kind of, you see, the position oriented approach, they tend to lose sight of the interests which they may have, the long term interests. So whether it is the family dispute, the commercial dispute, the employment, work related dispute, or any such thing, the matters which are capable of being resolved through ADR mechanisms, where the parties, if they adopt the traditional approach which is there in the courts, that is totally adversarial, that is, one party makes the allegation, other party refutes, and the lawyers keep arguing cases of both the parties, and eventually the judges sit there as neutral umpires and they try to find the truth through those arguments, cross examination, that kind of thing. But here the ADR mechanism needs the maturity of the persons. The allegations, counter allegations, incrimination, recrimination, they are of very little help. The understanding is that the parties themselves want to expeditiously resolve the dispute. They are looking for protecting their long-term interests. So that's why they are supposed to be flexible. And if that flexibility is not there, or the stubbornness is there, so what the mediator is doing, that by asking very thought-provoking and even provocative questions to enable the parties to see beyond what the rigid position they have adopted, and gradually see take forward that discussion which allows the parties themselves to see what is in their interest. So they realize. So that's how the role of mediator is there. And here is which chartered accountants can play a great role, especially in commercial come family disputes. That parties, you see, who are becoming either emotional and therefore adopting very rigid position. So if by having that conversation, mediator is trying to facilitate the conversation between the disputing parties. So if the parties are enabled to see what is their long-term interest by that conversation, so that helps them. And eventually, see, when me either in one meeting or more such meetings which are happening in mediation, so the parties can arrive at a settlement agreement, and that settlement agreement at the end, through the representative of the parties, can be formalized. So there can be some memorandum which they want. So the representative of parties can be there in mediation sessions. There is also new trend that means, since litigation is to be avoided and ADR mechanisms are to be followed. So somewhere it is happening. If you look at it, see some of the advanced jurisdictions like Singapore, what they have done, that mediation plus arbitration, it is called hybrid clause or multi-tier dispute resolution clauses. So simultaneously there can be mediation and arbitration, or parties can try first arbitration and then mediation, or first try mediation then arbitration. So wherever you see me they succeed, that will be welcomed. So again, you see here the role of CAs is going to matter, whether it is the construction dispute or commercial dispute or any such dispute. If the chartered accountants, in addition to the domain knowledge there, if they are being trained in these ADR mechanisms also, so they can be there as dispute resolution professionals who have seen. So arguing the case for the party, that is one thing. Second thing, somebody who decides the case. So also we can be a mediator or the arbitrator. And another thing, that experts are required from time to time. The now this Los Angeles case I was telling is about the fire, the extensive fire, where you see the billions of dollars worth property is lost, or this kind of the war related situation. If such mega disasters are there, or even in our day to day life, very small cases in our neighborhood, or the big projects like the uh, metro, where the property damage can happen, or deforestation, environmental issues. So extensive knowledge of the domain plus the trading in ADR, that can again is equip the chartered accountants to play multiple roles. They can be there, see, playing various hats. In addition to being chartered accountants, they can be the persons who are arguing the cases. They are the ones who are deciding the cases, and also they are invited as experts to help the dispute resolution, the committee there. That is, if suppose the council or the people who are arguing the cases, they also need assistance, and the tribunals or the mediation, they also need assistance. So being on the part of the panels of institutions or available through online means, also writing and uh, participating in conferences, writing books, blogs. These are the various avenues which can ensure, you see, your outreach to the prospective parties. People should know that there is somebody in this field. So he or she is chartered accountant plus has training and experience in mediation, arbitration, and is available. Uh, Look at, you see, these issues, and in the larger sense, that to ensure justice, peace, and harmony, what the role CAs can play in these fields. So their knowledge is of great relevance, and it is desperately required for society. Even the tax disputes in the foreign countries are being thought of to be settled through ADR. They traditionally see me. It is understood that the public policy matters or the constitutional matters should not be settled through ADR. But there are, see, disputes like intellectual property rights, like the patents, trademark, geographical indications, the taxation. These matters where the rights in rem and rights in personam are separate. If the dispute relates only to the private rights of the parties, that is, the decision of the ADR is not going to adversely affect the rights of people at large, that is, those who are not party to the dispute. In that case, the matter can be settled through ADR. And here again, you see the role of CAs will be of great importance. The lack, the deficit which the traditional lawyers have in these fields, the deficit of knowledge in these fields. So that can be on the vacuum that is there. So that can be easily filled by people from other professions, including those who are there practicing chartered accountants. So rest assured that the field of ADR is very promising. So one should prepare oneself. This is the time to tighten the belt, take the ADR mechanism very seriously, get trained. Those who are already trained, you see me, they can diversify their field, join the institutions, availability, and the willingness to uh, expand one's horizons, to contribute to this field. They will be of great requirement and necessity. So that's how me I think, you see, that the CAs can play a very, very valuable role, an important role in ensuring peace, justice in society. So these are the brief remarks. Now, if you would like to ask any question, so please go. So we can have more time for interaction. Thank you so much.
Dear participants, in case any questions, you can ask.
How many participants are joined?
So around 1 sec. 260 participants have joined,
Oh my God. Great.
and around, yeah,
Which are the fields in which you see these CAs can contribute? In fact, let me ask the question so that we can you see have the discussion. The,
basically CAs can contribute in this ADR also, and we have even discussed about this new domain.
yeah,
Um,
my point is you see how to me dovetail the existing knowledge of the domain knowledge of the chartered accountants and the requirement of dispute resolution. So for that, this training is required either
yeah,
as mediator or arbitrator or maybe both also. And many institutions are available for that. And the training is available online as well as offline. Getting training will be required because once the institutionalization is done, so accreditation will be required.
okay.
It will be a kind of professional approach.
So we have one question.
Yeah.
What is the process to register as ADR?
No, as of now, you see there is no such kind of formal registration. The expectation is that you see the Arbitration Council of India and Mediation Council of India will be soon set up. We were hearing this thing for quite some years, but these two council are yet to establish. So at present, anybody can start the ADR service provision. Like just me, if you want to be a lawyer, chartered accountant, doctor, you need is specific training. But for mediator and arbitrator, as of now, there is no such requirement.
Okay,
So one can use one's existing domain knowledge also to start, you see, these services. There is no such kind of you see, registration. When the MCI, that is Mediation Council of India and the Arbitration Council of India, they will be set up, then they will prescribe these specifically how to become an accredited arbitrator, how to become an arbitrated mediator. But if you look at the international practice, so there this training is there. 40-hour training for mediation. It's a very general training. And the training separately for arbitration. Day before yesterday, Indian this FICI Chamber of Commerce, they launch. I mean, they are having this Indian Council of Arbitration, and day before yesterday, they decided to launch the mediation rules in India. It is something unprecedented because even the government has not set up the mediation rules, and that will be done only by the Mediation Council of India. So that was the leading initiative, and there the panelists who spoke on that occasion, they emphasized the need to have specialized training for commercial mediation because the 40-hour training for mediation, that is very general. That gives you see the people the general is understanding that what role the mediator is supposed to play. That is the confidentiality, ensuring you see the neutrality, giving equal treatment to the parties, ensuring you see there are no biases, both the parties are heard, and parties are given full control. That is the dominant aspect of mediation. So there they were talking about there will be a training requirement, additional training requirement for commercial mediation. That also we need to bear in mind. And here again, you see the CAs will find it very easy because they already I see the exposure in this field, extensive exposure. So resolution of commercial disputes come family disputes. So though those who are not from this field, they and if they want to be commercial mediators, they will certainly need training in commercial mediation. But for CAs, it will be less required. But if it is formally done, that's even more helpful.
Exactly so. So, and we have multiple questions like what are the qualifications required to be done?
Yeah. So just as registration, so same thing applies to qualification also. That as of now, I mean, no formal qualifications are required. But if the Arbitration Council of India is set up, Mediation Council of India is set up, then they are going to require, I mean, they will state, they will prescribe that people you see who want to be arbitrators, who want to be mediators, so what kind of BC qualification they should have. I mean, generally, this training will be there because the idea is to use the existing domain of knowledge in various disciplines. So people can be from banking field, insurance field, science and technology, architect, medical, engineering. So, all people you see from these fields are welcome to join these dispute resolution fora or the institutions and contribute to psychologists, psychiatrists, because the nature of dispute will decide the diversification and broadening of the pool of dispute resolution professionals in advanced jurisdictions or the Western jurisdictions is very, very broad. Here is we are confined to lawyers and retired judges. That is not the case internationally. And the experience shows in many UC places that the different domain knowledge and the experience that people bring that enriches the dispute resolution. So the some kind of institutional memory that lawyers and judges have of the rigid procedures, so they have to be avoided. And for that, the the panels are formed in such a manner that the panels of mediators in foreign jurisdictions, that the panel is of different, you see, backgrounds. Like somebody will be from science and engineering, if requirement is there. Somebody will be from this chartered accountancy. Somebody will be from law. That ensure that you see the in the same tribunal. So there are see, people from different backgrounds, and their knowledge can be used comprehensively in settling the dispute. So as of now, you see the registration for that it is not there. Likewise, qualification also. But it is certain that the existing knowledge of different professions is to be used, and for that, just additional training as arbitrator or mediator has to be imparted.
Yes, sir. So, one more question.
Yeah,
When is the Arbitration Council and Mediation Council expected to be set up? Approx within what time frame?
there is no specific time frame given, but very soon that should happen.
Okay.
But in the meanwhile, you see people you see who are getting training or who are in experience, so there is no bar on them from starting the services. So that's very important thing. So one need not wait for that moment.
Okay. Any other questions?
Because disputes are going to rise, that is for sure.
Absolutely.
The, the nature of society is becoming such that everywhere you see problems are going to be there, and the courts cannot handle so many matters, and the time which it takes and the bitterness that it various you see problems in society. So that is to be avoided. And in
Mediation
fact,
is silent resolution of disputes.
yes, and in fact, this ADR, alternative dispute resolution, initially it was supposed to be something that was opposed by lawyers because of misunderstanding. So some may they used to think that there will be alarming drop in revenue ADR. That was ADR. That was another issue. But later on, it was discovered that no, it is appropriate dispute resolution, and ADR does not bar the lawyers and the people we see from judiciary, retired judges, from coming to this field. So there is no need for anybody to have any apprehension. Likewise, chartered accountants also, whoever is coming, so they are bringing, you see, their domain knowledge plus experience and expertise. If the motor vehicle accidents are there, or you look at, you see the satellite, you see the issues, the space debris, collision of satellites, and what happens. So there, people who have just studied literature or political and sociology, what kind of contribution can they make? There you will need to see the scientific knowledge, science and engineering, plus the dispute resolution expertise. And there also again you will see that the satellites, they are so expensive, or now these space missions which are being sent on a very large scale. So there we valuation is going to be very important. Valuation and assessment. Who can play that greater role greater than the chartered accountants? The number of the lawyers, they have the phobia of mathematics, statistics, accountancy.
Exactly, sir. So, shall we conclude?
We can wait for a few more questions.
Okay.
But as of now, you see, there is no bar on anybody starting to offer these services in absence of any rules and regulations. So whoever is, in fact, if there is no requirement even for any training as such, but
I have one
those
more
who,
question. Go
yeah,
ahead, sir.
those, those who are totally new to the field, so for them is it will be beneficial, so that the parties or the clients keep coming to you. Their training as its own is a significance.
So, there's one question.
Yeah, yeah.
Can you please give more examples of ADR? As currently, CAs are already occupied in many things like consulting, taxation, and all. So, how ADR will enhance the current role of CAs?
As of now, what happens that you see, whenever any dispute arises, so it goes to court, the traditional understanding. So it means that the role that the CAs have to play, that is confined only to the audit, taxation, that kind of thing, balance sheet. But if the matter is not going to be sent to the court, because you see, that is going to be gradually see the dispute resolution policy as such. Right now, you see, mediation is not mandatory. The reason for that is that we do not have adequate number of the mediators who are trained. That was the reason that Parliament did not make it mandatory. But the moment you see it is made mandatory, you will see that that is even before litigation or arbitration. You have to start with mediation only, and in that case, uh, the mediators are going to have a great role. So the chartered accountants, uh, every time we see have we so far they remain confined to only to this uh, commercial matters only, or and any dispute is to be settled through court only. So now that is not, once mediation is becomes prominent, so that will not be the case. And that's why here you see the getting training in this mediation and arbitration is very important for the chartered accountants, and that will provide them, you see, the new avenues, and they themselves, you see, will be able to see that how me critically see their role is going to be. It's not, you see, the giant multinationals, but the LLPs and the startups, is the small and medium enterprises. Everywhere, you see, there is me requirement.
Absolutely, sir.
Disputes, yeah, not just you see the billions and trillions of dollars, but the small scale also everywhere. And it will be, see, the kind of the cottage industry. It will flourish. So there is scope for everybody to rise. it will be an extension of your the role as chartered accountant. So it will be CA plus mediator, CA plus arbitrator.
Exactly.
Because if there is a dispute related to the taxation itself, there is what just me what as of now people are see informally advising and not getting anything in return for that monetary benefits. So that will be monetized actually, and also the tribunals need the services of experts. So CAs can also be the experts in those various fields. So this Viksit Bharat 2047 or making India, you see the advanced economy. So that is going to generate more and more opportunities. So
Right.
having this training and the exposure and the willingness to go beyond is one's traditional domain knowledge is very important. And be active. The party should know that there are people who are specializing in these fields, because the mediation and arbitration they are party driven. Even in like litigation, we go to lawyers who are very famous. So, chartered accountants who are also they are also approached by people because you see their approachability, their work, their experience. So same thing will apply to this mediation arbitration also, and it will be to the great advantage of the parties that if they are having the person who is CA as well as mediator or arbitrator, so it will be good for them also. I mean, they don't need to go to too many C persons for settling their cases. And once the mediation is done, so if it is successful, then there is no need to go to court. But if somehow there is no success, then it can go to court. So the effort is to minimize the number of cases going to court, and sooner or later the mediation may be made mandatory. Internationally, I mean, some countries this experiment was done. There it did not succeed for various reasons. So in some other countries they made it voluntary. So as of now in India also it is voluntary. But the reason for making it voluntary is that the lack of adequate number of trained mediators. Once the mediators, the trained mediators, they rise, so this can also be made mandatory. And even if it is not made mandatory, but what happens in the market, that also matters. That if the dispute resolution professionals, that is mediators and arbitrators, they are there offering their services, and if the parties come to them voluntarily, of course, everything is voluntary there, and if their experience is good, then the through the word of mouth, the mediation can be popularized. If the mediation industry as such, or the mediation profession rather, that is able to create this kind of the image in society on the basis of we see the real experience of people, that mediation is something that saves time, that is saving time may or and reduces the cost of dispute resolution, and eventually see it's a win-win solution for all the parties to the dispute. Because in court what happens that the court decides in favor of only one party, because the nature is the method is such. In arbitration also almost same thing happens, except that the speed is little faster and the parties have the choice to have arbitrators of their choice, law of their choice, forum of their choice. That is not possible in the court. You cannot have judge of your own choice or law of your own choice. In mediation it is even the less stricter, but the process is driven by parties. Mediator is there only to facilitate the discussion, asking the questions so that the parties can see what is in their interest. So somehow, when they realize this, that their rigidity is going to harm them, then they try to reconcile and they become flexible. So that is the role that mediator plays. Even in our like you see family disputes, flexibility is required. So people who have you see these skills and who enjoy conversation with others, so they have very great future. So extrovert nature is required. That is also another thing, because if somebody is very introvert or doesn't want to get bothered by what the others are saying, if parties are sitting there and you see one is not listening to them or there is no eye contact, so parties may think that you see we have come to this person, but he is not even willing to listen to us. So that should not happen. So willingness to listen to them, paraphrasing what they are saying, confirming whether our understanding of what they have said is right or not. That is very important. And CAC is assumed and expected, and that is true also to a large extent, with few exceptions, that they already have, you see, these skills. They are having you see, so much of experience and exposure. So that knowledge and experience can be of great help in these fields. Even if they want to confine themselves only to their domain knowledge and the disputes related to that, that's also fine, because the opportunities are going to be many more. So it's an additional thing. CA plus mediator or CA plus arbitrator.
Exactly, sir. So there is one more question.
Yeah,
In present system, there are multiple levels of appeals. The case is being debated at multiple levels, from district courts to high courts and then to Supreme Court. Will ADR avoid this and will help in faster resolution? How this is uh, how this is being addressed in ADR to avoid multiple levels of appeals?
yeah. You see, it's a very important point, because the legal and judicial system, they are, you see, there to ensure the protection of rights of all people in different types of disputes. So matters which are of public policy, so they cannot be settled through these means. That is very sure. But when private disputes are there, whether commercial or non-commercial, and the parties themselves decide that they want to avoid this lengthy and rigorous procedure, because it is in their enlightened self-interest, commercial interest, personal interest, that they want to settle the disputes quickly, and therefore they voluntarily choose to adopt either mediation or arbitration. So here is the question of those appeals doesn't come. But if the parties is they are not satisfied with the arbitration or mediation, then they can go to court. But if that's why I'm saying, you see, that the maturity of the parties also matters a lot. The success of mediation and arbitration in a particular jurisdiction depends on the attitude, outlook, the perspective, and the nature of the parties. If law-abiding nature is there, cantankerous nature is not there, people really want to do their work is sincerely, honestly, then ADR is really helpful. But if the mediation or arbitration is going to be used only as an excuse, and then later on again people are going to court, then it is bound to be defeated. So the thought process and the honesty, sincerity, ethics of the parties also matters a lot. Otherwise, our experience of arbitration in India is not very encouraging, and that's the reason that the many cases from India, arbitration cases, keep going abroad, because of the attitude of the parties and also the judicial decisions. Of course, during last few years, you see, there has been a great deal of change. Mediation is coming after this litigation and arbitration. So mediation again is, so it needs even more, you see, the maturity. If the parties are not honest and sincere, and if they are coming to mediation just as with some kind of, you see, the delaying tactic, then the mediation will not succeed. But if the parties, as you see, wholeheartedly agreed with the principles and the ethics of this, then they can succeed. And they, because success of mediation depends on the nature of the approach of the parties. So the appeals which are in the judiciary, they are to be avoided here. Appeal, going in for appeal means what? That the losing party is not happy with the outcome. So they would like to get it challenged at the higher level. So that's why the 20 years, 30 years, 40 years, you see these matters keep going on. And that is not good for society. And if those parties who are convinced that they do not want to get into these hassles and they want to settle their disputes quickly and effectively, efficiently, and they want to have a peaceful life, have good relations with the other party, then for them this is good. Otherwise, the route of litigation are always there. The mediation, arbitration, they are not going to prevent anybody from going to the court. I mean, one should rest assured that. So that's why mediation is voluntary, arbitration is also voluntary. You can give up mediation at any point of time.
Yes, sir.
So attitude of the parties is very important. If they want to continue the dispute, because in courts this happens very often. That very often is we say that there are so many cases in the courts, but the reason is not merely judges or the lack of number of judges or the strikes by the lawyers and all that. That is not the thing. There are many parties who are not keen to settle the dispute because it is in their interest to delay. If that approach comes here also in mediation, so you can see what will happen. One need not be say, any kind of specialist to forecast this. So the willingness to settle the dispute, to lead a peaceful life, honest life, that is very important.
This is the disadvantage of this.
Disadvantage in what sense?
That other party is not willing to settle the dispute.
Yeah, yeah. They can, you see, me keep, you see, finding some excuses. Sometimes you see they will not come. Sometimes the lawyers are not coming. That kind of thing. Eventually, the ex parte orders had to be passed in some cases, but that happens very rare. In some of the advanced jurisdictions, courts also impose heavy costs on such dealing tactics of the parties, and especially in matters of arbitration. If you look at Singapore, so the courts, Singapore courts, are imposing heavy costs on the parties who challenge the arbitral awards just because they lost. Because the arbitral awards can be challenged on very very limited grounds. Just as you see the some kind of bias of the arbitrator, fraud, corruption, or the arbitrator decided that the case which was not even argued, something the relief which was not sought. In those cases, or the appointment of arbitrator was not done in a fair manner, arbitrator did not give the parties equal opportunity, procedures were not duly followed. So these very restricted grounds. That's why it's different from appeal. In yeah, the very very few grounds are there, but in India, such costs have not been imposed, and that's why the even the arbitration matters is keep going on and the lingering disputes. Now the effort is being made to start mediation. Now let us see what will be the experience after a few years.
Is the information public about this? How many cases are resolved outside court or something?
From where? Like if you look at, you see me, that's why you see you need to go to institutions. If the practitioners are individuals, suppose you see I'm a lawyer and I'm also working as mediator, arbitrator, and if I'm not, you see, having any website of mine or blog and where I'm not sharing these things, so that will not be known. But if you go to the institutions, so there you may not know the names of parties and all that, and who was the arbitrator, mediator, but you know the statistics. Suppose Mumbai Center for International Arbitration or Delhi International Arbitration Center or London Court of International Arbitration. What happened that you see these institutions have their websites, and every year they upload the statistics that how many disputes came to them, how many were resolved, how many are pending, that kind of thing. And as far as the statistics of courts are concerned, they are already there on the in the public domain on the websites of the courts. And one more thing, the mediator is is it is not the job of the mediator to ensure that is a dispute is settled. It is, you see, the principle of ownership. Since the dispute belong to parties, so this resolution should also belong to the parties. All that mediator does is it ask the questions so that the parties you see can think of what is in their interests, whether they can transcend their traditional and rigid positions and see the protection of their interests go by reconciling and being flexible. And if that is not possible, if they are very stubborn, then court is there for them. So ADR requires a great deal of the willingness to be flexible and willingness to do introspection. If only blame game is to be done, then court is there, and then the other mechanisms. So voluntary compliance is very important. That even after the because it is seen in various jurisdictions, including India, that arbitral awards are not complied with, and people think that this ADR is something very substandard. There is some already we are having something called lok adalat. So popular perception is that the any order or the judgment that is coming from court has you see the strength. It is easy to enforce. If it is not done, then law will be very strict and punishment will be there. So people complain that you see same thing does not happen in the case of ADR, but that is happening because the people are not you see willing to obey the choice they made of mediation or arbitration, and now when the outcome has come, they are not willing to accept it. So that is something sad on their part. That is not the reflection on the success of the ADR or the ADR practitioners. If the arbitrator or the arbitration tribunal has rendered an award of, or if the mediator has uh, been able to, you see, help the parties to reach a settlement agreement. Now, after the settlement agreement is signed by the parties, and if they want to backtrack, so who can prevent them from doing so? And in that process, they are going to harm themselves. That does not necessarily reflect on the success of the mediator or the mediation as such. Likewise, if the arbitral awards are going to be challenged by the losers and various allegations are going to be made against the arbitrators, so again, that does not speak of the success or failure of the arbitration as such, unless and until these arbitrators are involved in some really illegal things. But if the challenge to the award is merely because a party has lost, then that is not good for the parties and also to the society as such. But these are the things which are gradually evolving. It is for the person and their conscience.
Right, sir. Any other question?
But training is important. Right now, you see, there is no such requirement. But so even by associating with some practitioners, one can join. But getting some formal training, that is me once these mediation and arbitration council they are set up, so it will be required accreditation. But again, one doesn't have to wait for that to happen. Training is being offered by so many institutions. So go ahead and start the dispute resolution services. And it can be done online also. Even Niti Aayog is encouraging online dispute resolution, ODR, ADR plus ODR plus chartered accountant.
Right, sir. And sir, one more question.
Yeah,
What is the type of cases can be litigated ADR tribunals? Will it be criminal cases or drugs cases come under this?
no, sir, as far as criminal cases are concerned, they are totally away from the jurisdiction of the ADR. So what is me anything that involves the state or the government or the so criminal cases, constitutional law cases, they are not to be decided. Public policy matters, they cannot be decided through ADR. The matters which are having you see the rights of only the parties. In other words, the civil matters, property matters, commercial disputes, where the decision of the mediators or arbitrators is not going to have any kind of you see the adverse effect on the rights of others in society. That is, those who are not party to the dispute, their rights should not be affected. Fundamental rights uh, or the constitutional matters, they are going to be decided only by courts. ADR or the other matters where rights of private properties are involved, parties. Criminal drugs, they are totally ruled out.
Right, sir.
In future, we don't know what will happen, but as of now, that's not possible.
So, shall we conclude?
I don't know if somebody has some other question. But it's a promising area. I mean, that much is quite sure.
So there's one more question.
Yeah.
What is the basic difference between arbitration, mitigation, and reconciliation? When can a party opt for arbitration, reconciliation, or mitigation?
Litigation is going to court straight away. See, me the choice of the party that me, as far as see the arbitration mediation are concerned, here the parties you see have to sign an agreement. Without that arbitration, me without the consent of the parties, arbitration and mediation cannot start. Also, the arbitration and mediation you see they are confined to only those cases In arbitration mediation, you see the parties have the choice which forum do they want to go. That does not apply to the courts. Court, wherever you see in the jurisdiction where the dispute has taken place, so court who has jurisdiction over that place will handle the case, and the outcome of the court proceedings, because the nature of method is adversarial, only one party wins. In arbitration also same thing happens, but in mediation it is possible that you can have win-win solution if both the parties, through the conversation that is facilitated by mediator, if they are somehow willing to see what is you see in their interest, and they gradually see change their rigid positions and start thinking of protecting their interests. In that case, then it becomes successful and it's a win-win solution. So both the parties can have the favorable outcome. That is not possible in mediation and arbitration, the arbitration and litigation. But in mediation, it's possible.
So what is the statute which governs ADR? And secondly, people are asking about the remuneration for ADR service. It's fixed or collected from both the parties equally.
First of all, you see the statute. So there is no ADR statute as such, but you see there is Arbitration and Conciliation Act, and now there is Mediation Act. That is one thing as far as statutes are concerned. And the remuneration to the Arbitration and Conciliation Act after EC 2015 amendment, you see they have you see given the remuneration rates. But again, it is you see up to the choice of the parties, because if they want to see some high profile arbitrators or mediators who are international known, or if they are foreigners, but that is another thing, that in mediation and arbitration you can have see the persons of the other nationalities also. So they will you see obviously need to see the high remuneration. But again, you see it is the discretion of the parties. If they cannot afford the services of certain mediators or arbitrators, so they are free to look for somebody else. As of now, you see the people you see who are you see international practitioners, they do not see the permanent offices in India, but then their charges will be international. Whatever happens in other professions, so that applies here also actually. Whoever is more in demand will have the higher charges, and there is no kind of imposition of anybody. It is easy for the parties to make their own choices. Statutes, there are separate statutes. There is no nothing called ADR as such, but there is arbitration statute, Arbitration and Conciliation Act, and then there is Mediation Act. Mediation Act is very a new one. Just last year it was adopted, and Arbitration Act is the amended one. Otherwise, it was there since 1940, but in 1996 it was a new act was this passed. So it was amended in 2015, then subsequently in 21, 23. Now again, you see there is 24 you see amendment also, bill also. So every now and you see me, they are trying to update for various reasons. So every amendment is leading to some kind of either silence or absence or some confusion or some new problems crop up, and therefore the law has to be amended. Mediation, although India signed the Singapore Convention, yet it does not see ratify. It is yet to ratify that. So the mediation in India is primarily for the domestic issues. The international commercial settlement agreements, mediated settlement agreements. So about that, as of now, you see me, there is no clarity as such. But over a period of time, see me, things will improve.
The next is whether after dispute is settled, can the benefited party may still go to court after being satisfied with the resolution after a later point of time.
You see, me going to court, you cannot stop you see people from because you see that's a very fundamental constitutionally is a guaranteed fundamental right to seek justice. The only question is, you see, what are the grounds which they are going to take? That is one thing, and whether those grounds will be acceptable to the court. And even if they are accepted, you see, the parties can provide proof whether the law will allow. Just as I was telling about arbitration, that when the dispute is settled through arbitration and the award is rendered, it is the experience in India that the losing party invariably goes to court. In fact, parties to arbitration go to court even during arbitration or before the start of arbitration. So arbitration proceedings can be challenged at various stages. That right at the outset, that they can say, "See, we did not sign this agreement to arbitrate." Then, if the arbitrator is appointed, they will say, "See, our consent was not sought, or the arbitrator is not qualified." I mean, they can make some allegations against arbitrators. And when the arbitration is going on, so sometimes they may not attend, or they can go to court and seek an injunction. And if everything is done after the award is rendered by the tribunal and tribunal ceases to exist, it becomes non-existent, functus officio it is called. So then the party can, the losing party or maybe even the winning party, we don't know. If winning party says that they did not get what they wanted, although they won, so they can be challenged on that ground also. So the court will decide. So the very purpose of having this ADR can be defeated if parties are having this approach. And also the professionals who are going to practice arbitration and mediation, if they are also not going to follow all the rules and procedures very sincerely and honestly, and if they leave some kind of scope or the loophole for the parties to challenge, and the court also finds that loophole actually. So making an allegation is one thing, but providing proof and persuading the court, so that is another thing. So if the courts are also coming to that conclusion on the basis of the proof that is going to be provided by the parties after me up on the basis of what the arbitrators or mediators have done, so that is not a good thing. And the role of courts is again very important. Just merely because the courts have too many cases and disputes are to be settled expeditiously does not mean that the arbitrators or mediators can do anything and everything. So law is there, so they have to follow the law. And if they are going to be involved in any kind of practice that is unethical or illegal, so the mediated settlement agreements or the arbitral awards, they are going to be challenged, and the evidence will be there with the challenging parties. And then courts are going to invalidate all such things. So that's why the sincerity of the dispute resolution professionals, that is of uh, very critical nature. So arbitrator must ensure that the award that is rendered is enforceable. Even if it is challenged, it should not have any kind of loopholes and the challenge should not succeed. Likewise, the mediators also have to follow the rules and procedures honestly and sincerely. And they should not leave any scope for the parties to make allegations. And even if allegations are made, so there should be, if the allegations are baseless, so there will be no proof. So how sincerely ADR professionals are taking their profession, that is very important. And that will decide the future of this domain in India. If arbitrators are found to bias or there is rendering awards on the basis of the consideration of the future job prospects, future appointments, so that can become very serious matter. And likewise, if mediators, they are also doing something which the law does not expect them to do, then that is not again is good for themselves, for the mediation profession, and the overall is the ADR mechanism as such. So the reasons which uh, force people to go to court, that is the enforceability, if they are not going to be here, that if the arbitrators are going to bias or if they do not disclose their interest, because this is very common, it is the common standard requirement all over the world. The ADR professionals, that is arbitrators and mediators, they must disclose their conflict of interest. And if that is not done, then that leads to these future is disputes. And even the some leading persons in the field, they are also is found to be guilty of such malpractices. So transparency is very important. Taking ADR seriously, both the parties and also the professionals. You look at see the way arbitration is practiced in India as of now, because the institutional arbitration is not very prominent. What is happening? The ad hoc practitioners, that is the lawyers and retired judges. So lawyers who are practicing in the court until the afternoon, and then they start the arbitration only in the evening for 1 or 2 hours, and then they are there on weekends and holidays. In contrast with that, if you go to advanced jurisdictions, there you will see that arbitration is a full-time activity, mediation is a full-time activity. So parties are also serious, the profession are also serious. So that shows the overall nature of that jurisdiction and the society also.
Are there any rules or regulations or standards applicable to arbitrators? Who will review or regulate them, their services?
Yeah, again, you see, it's a very important question. International Bar Association has made you see certain you see the rules, but again, you see these are soft laws. As far as India is concerned, when India amended the Arbitration and Conciliation Act in 1996, so at that time they incorporated the IBA rules and guidelines. So in that sense, India becomes the first jurisdiction in the world to make those the soft laws of IBA as hard laws. But that is again, you see, the IBA guidelines are applicable to primarily to those who are members of IBA or the legal profession. Internationally, see, there is a great deal of debate on this issue. But if you are working with some institution or if you are empaneled by some institution, then the rules of arbitral institutions will apply to you. And in this era, we see this digital technology and the transparency because of communications technology. So parties are bound to find something somewhere, like the LinkedIn or Facebook, Twitter. These are also the sources. Just as police are able to trace some criminals through these platforms, so even the parties are able to find something or the other about the arbitrators, mediators, and for that matter, anybody in society. So declaration of conflict of interest by the arbitrators, mediators is very important. Equal treatment of parties, that is also important. Remaining unbiased, that is equally important. And in mediation, it's fully party driven. All that because in arbitration, arbitrators give an award. In court, judges are giving the judgment. But in mediation, mediator is not going to give anything, any solution as such. So no prescription or solution. All that mediator is doing is to facilitate the conversation between the disputing parties. And now this is going to be very important for all of us because every dispute will come through mediation sooner or later. First platform or the forum will be mediation. In like it, I was telling about the example of Italy. They made it compulsory. So if that also happens here, or if the court asks you to mediate, or if the parties decide to have mediation, so what mediators are going to do or have their experience, that will matter a lot. So unbiased approach, independence, impartiality, objectivity, declaring conflict of interest, and not giving any treatment which the parties have not asked for. To give any kind of award on any issue or give relief on a matter which is not at all sought after by any of the parties. So that can also be a ground. If suppose there is an arbitration and both the parties have argued their cases, now they have made their prayers or what exactly relief do they want from the tribunal. Now tribunal thinks that something is missing from the pleadings or the arguments of the parties, and arbitrators are going to add something on their own. So that will create a problem because after the award is rendered, the parties can go to the court and say that we never sought this relief and still the tribunal has given us this relief. So what is the logic or rationale behind this? And in that case, the court will again reject such award. So it is not the responsibility of the mediator to settle dispute. Mediator is there to facilitate the conversation, and parties can find on their own way what is in their best interest. And once they realize what are their interests, they will get to that solution. In arbitration, it is not the job of arbitrator to provide relief on a question which is never argued. Only on the basis of what the parties and their representatives or the council have argued for, the relief has to be given through the award. So these the compliance with the ethics and the procedures as well as law. These are very important. In case of any kind of violation of this thing or allegations of violations, the court will look into these matters. And court is going to have the supervisory role. So I was again just reminding that merely because the ADR is there, that doesn't mean that court is going to be totally away. Courts are going to be there always. And since the arbitrators and mediators, they are not perfect persons, perfect beings like me, anybody. So some institutional mechanism is required, and that's why courts are there. But they are there to help and facilitate the dispute resolution. But if in that process the arbitrators and mediators are going to do some mischief, then the courts are going to stop it. There can be the penalties against the such defaulters, the individually arbitrators and mediators. So penalties can be in terms of the person being, if you get adverse publicity, that's also kind of penalty for you. Because once your name comes in public domain as somebody who did not declare the conflict of interest or who went on supporting one party, so that will be a deterrent for the parties in future, other parties, to approach you for settling their disputes. So me, there can't be anything more harmful than that. In addition to that, there are some bigger the fines and all that. That's a separate issue. Arbitrators are also required to be abiding by the deadlines. If you look at the Arbitration Act and the 2015 amendment, so initially they prescribed the deadline for the arbitrators to render the award. It was supposed to be 12 months, and it was challenged by the foreign institutions because they said they need longer time, and they already have a lot of experience of this field, and they need about 2.5 years, 3 years. To international arbitration institutions and the arbitrators, they were exempted. But the domestic arbitrations and the arbitrators in India, they have to follow these deadlines. At the most, they can get the 6 month extension with the permission of the court. And if that also doesn't happen, then there can be fines. So the whatever is the fees the arbitrators may have charged, so there can be deductions from that fee. Fines will be levied and deducted from the fees of arbitrators. And the experience has shown that, at least in case of India, that the pace at which the arbitral awards are being rendered, the domestic arbitral awards are being rendered by arbitrators in India. So that has uh, become very fast. Otherwise, it was very, very slow. So monitoring and supervision of the ADR professions, ADR institutions, that is very important. Although at present you see there is no such mechanism, but the advanced jurisdiction they are having this. So the arbitration council, mediation council, they are also supposed to do these things. So let us wait and watch as and when they will come into place. But even in absence of that, all of us are who are going to be associated with these activities. So it is for us to make our own mark by rendering the exception services. So just as doctors, chartered accountants, lawyers, engineers, they are known for the quality of service they provide, and that's why people have approached them. So same thing will happen to these arbitrators, mediators also, and the institutions which are going to have these roles. So law, ethics, professionalism, domain knowledge, expertise, availability, conflict of interest, declaration of conflict of interest. These are of enormous significance, and it's a serious activity, serious profession that needs to be taken seriously by parties as well as the professionals. In absence of that, people are bound to think of ADR as something bogus or nonsense, and I mean there will be no faith in the ADR, and people will go to they will keep going to courts. In fact, they will be forced to go to courts. Those parties you see who are aggressive and stubborn, they may be you see going otherwise also, but those who are willing to come to ADR, if they have the bitter experience, then they will not be inclined to come. They will lose faith in this entire process. That is the biggest risk. ADR needs to be taken seriously by all stakeholders. It is not some kind of you see the additional activity, but it's a full time that needs dedication.
Right, sir.